Hi, welcome to Lawline in the News. I'm David Schnerman. In today's segment, we're talking about the Cherokee Basin versus Owens Supreme Court case, where the Supreme Court found in order to remove a case from state court to federal court, the defendant no longer needed to show evidentiary submissions. All they need to show is a plain statement. This is a reversal from the 10th Circuit's and lower court's rulings over the past couple of years. With us to discuss this today and the significance is Deborah Renner, who is the lead to the class action group in New York at Baker Hostetler. She's also the founder and former editor of Baker Hostetler's class action lawsuit defense blog, as well as runs her own blog called RennerClassActions.com. How do you find the time? Thank you for being here.
Thank you, David.
Deborah, last year, the Supreme Court in Standard Fire Insurance ruled that a plaintiff cannot keep a case in state court by stating too low damages. As a result of that ruling, the 9th Circuit said that they changed their ruling from a legal certainty to preponderance of the evidence of what you needed to remove a class action lawsuit from state court to federal court. This is all in the interpretation, of course, of CAFA. After they did that, a year later, we're back in Supreme Court now challenging that. What's going on here?
Well, as you know, David, CAFA was passed, the Class Action Fairness Act was passed in 2005. So it's been around for about 10 years, and I know that seems like a lot of time, but it really isn't in the life of the law. So a lot is happening now to interpret what CAFA really means. Now, in the Owens case, it was the removal context, and it dealt with the question, as you said, as to what needs to be shown in a notice of removal for a defendant to remove a case from state court to federal court. Typically, when a plaintiff has to state why federal jurisdiction exists, the plaintiff only makes a short, plain statement in good faith as to why federal jurisdiction exists. But the 10th Circuit put a different onus on a defendant, because the situation is really analogous, right? When a plaintiff brings a case, that plaintiff chooses state or federal court and states, an amount in damages, or just states, this case meets the federal jurisdictional amount, whether it's CAFA or not CAFA. So the 10th Circuit said, well, what we're going to do for defendants in the removal context, and by the way, this is not just with respect to CAFA in the 10th Circuit, it's also with respect to regular removals, so to speak, is the defendant's going to have to show evidence of some sort in the notice of removal that federal jurisdiction exists. So what happened in the Owens case is that when the defendant removed, the defendant didn't put evidence in as to why federal jurisdiction existed, but made a short, plain statement saying there's well over $5 million worth of damages here. In fact, there's $8.2 million worth of damages. And the district court rejected that. Meanwhile, the the defendant, said, well, I can show you through an affidavit. I can show you the evidence. Let me put an affidavit in showing you that there's more than $5 million in damages. DART went ahead and did that, and the district court still said, no good. You didn't do it in your pleading. Too late. You didn't do it in your notice of removal. So DART is allowed under CAFA to do an interlocutory appeal to the 10th Circuit, asking them to review the district court's decision. And the 10th Circuit rejected that request and said, we're not looking at this. So what happens when it goes up to the Supreme Court is we have a divided decision. It's 5-4, and we find very strange bedfellows. We see in the dissent Justice Kagan joining with Justice Scalia and Justice Thomas and Justice Kennedy. And the majority opinion written by Justice Ginsburg and joined by the remaining justices, including Justice Kennedy, says, forget it. There's no need to show evidence. In fact, if you look at the statute itself, it says you don't need to show evidence. Now, importantly, when the pundits were looking at this case, the general consensus was it would be a 9-0 decision, just like Standard Fire. And the idea was, well, the 10th Circuit just got it wrong, and the district court, they just got it wrong. So we find here that all the justices are saying the 10th Circuit just got it wrong. But because of a jurisdictional dispute, we have a dissent saying this case should never have been looked at. In fact, cert was improvidently granted. The majority decision says this is dead wrong, and we have a right to look at it now because it may never come up again. Right. And in addition, even though the 10th Circuit didn't really give a reason why it denied review, we can intuit from the dissent and from other factors that they were just following 10th Circuit law, which is just wrong. Under CAFA, and this is where standard fire comes in as well, under CAFA, if there is a dispute as to the amount in controversy, the court is to decide by a preponderance of the evidence which side has it right. And that didn't happen here, although the full burden was put on the defendant. So we have this decision that appears split on the surface, but in the terms of the substance of what CAFA means and what it's going to mean going forward, everyone agrees. The 10th Circuit just got it wrong. All you need is a short, plain statement.
So let's take a step back and talk about CAFA. In 2005, it was enacted when George Bush was president. What was the main reasons behind that legislation in the first place?
Well, that legislation was kind of a long time coming. For years and years and years, people talked about how there was going to be reform of the class action system because plaintiffs were filing their cases in state court because those state courts were more friendly than federal courts. And the legislation was supposed to make federal court more open to these cases. And that's why under CAFA you have relaxed jurisdictional requirements. You only need minimal diversity. And as you said, over $5 million in controversy, which generally is not so difficult to meet in the class action context.
So it seems like one of the things was to prevent forum shopping.
Yes.
And there were some state courts where a lot of class action lawsuits were being brought.
Right.
What went wrong, I guess? What went wrong in terms of how CAFA was meant to make it easier to go to federal court, and then all of a sudden it seemed like it backtracked over the years?
Well, it's a good question, and I'm not sure it's
And it depends who you're asking. Some people think it went right.
Yeah, I'm not sure that anything went wrong
Right.
per se. It's just the way the system
Right.
kind of plays out. So you have the CAFA law put into place, and you have plaintiffs trying to get around that law because they still want to be in state court in Arkansas, in Alabama, wherever, all of these friendly state court jurisdictions. And the standard fire case that you mentioned dealt with a different plaintiff's tactic. In that case, as you may recall, the plaintiff's counsel said, well, I'm going to just stipulate for the entirety of the class, for all the absent class members, that there's no federal jurisdiction here. We're not going to seek more than $5 million in damages. And what happened was Justice Breyer, writing for a unanimous court, said, no, you can't do that. It's not a certified class. You don't represent these absent class members. So you can't do that, and this tactic is struck down. So no more can a plaintiff just stipulate to an amount in damages. And here what we see going on is a plaintiff saying, well, I'm going to remain silent on the amount in controversy because the complaint in the Owens case didn't say anything about the amount in controversy. So then the burden in the 10th Circuit was put on the defendant to do so. And again, we see the court saying, no, you can't do that.
Well, Deborah, thank you for sharing on this timely topic, and thank you for watching Lawline in the News.